Very sorry.
Yes.
Bishop, I'm back to mention item number 2 to 13. It's another similar. Like this is after 2 weeks. I have not received.
Why?
I have not received any instruction. I'm for the Union of Indigenous.
Ah,
I have not received any instructions.
2 to 13.
Well,
What is state? What the state? State? What
they
if
have already filed.
saying what?
Compensation.
What do you stand there? Are they entitled?
In my para form, I've stated
Yawning.
decision taken by the village council.
Huh?
I've stated in my para form,
Huh?
the village council of Marangong village, representing the entire citizens of Marangong village
Anyway, who has to pay?
by the Union of India.
Okay. Okay. On the prayer of Mr.
Yeah,
Learned Council for the learned CGC. CGSC.
CGC.
CGC. Let these matters be listed after 2 weeks,
3 weeks, right?
3 weeks,
Oh.
so as to enable him to obtain instruction as regards the payment of compensation. Huh?
No.
Mr. So-and-so. And
Fusiko. For the petitioners.
Fusiko Pote and Mr. So-and-so. Land Council will petition and Mr. Are present. Huh? Okay.
Lordship, let this be the last opportunity.
Why?
In so much time, Lordship.
Why?
Several cases they have been
It's okay.
stating that
It's okay. Let's see.
waiting for instructions, but
Yeah. It's
not
okay.
quite like
Let's see. Yes.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 18.
Item?
18, 1-8. Lordship, I have taken the counsel of the petitioner. This matter will be listed after 2 weeks to
Okay.
file affidavit in the hardship.
On the prayer, Mr.
Team song.
Then additional advocacy.
Lordship,
Further 2 weeks time is granted. 3 weeks.
2 weeks.
2 weeks
3
is
weeks.
granted to file affidavit in opposition. Yes.
Lordship, I have a similar prayer. Hearing item number 22 and 23.
Why?
Here I have taken.
Hearing no adjournment.
Lordship, in this case, time will be given to me.
Why?
Because it was handled by some other council.
You
So I have taken over.
You have the brief?
No.
You have the brief?
No.
Just give the second file to him.
No, that will be very difficult.
Just
Lordship.
no, we'll take up at 2 o'clock. You will take up at 2 o'clock.
Anyway,
If there is any difficulty, we'll see.
Anyway,
Give him the second file.
Please, Lordship.
Huh?
I'm for the petitioner in item 22. My senior has some personal difficulties today, so
Hmm?
the matter can be adjourned.
No. When not adjourning? Who's your senior?
Take his Lordship.
Huh?
Take his.
Give the second file. You take the second file. We'll see.
Lordship.
We'll see. Second file. We'll take up at 2 o'clock.
Next week.
Hearing no adjournment. Sorry. We'll see if there is a difficulty. We'll adjourn.
Thursday, then, Your Lordship.
No. Today. Thursday we'll have a different. I mean, we have other cases. All right.
today,
2 o'clock. Yes.
May I please, Lordship?
Yes.
My lord, I'd like to mention item 16.
Ha.
Admission needs.
Ha.
If this can be taken up, I'll be filing preliminary objection.
What
So,
preliminary revision?
if it can be listed on 12.
Why? What is there? What is the matter
My
about?
lord, for respondent 3 to 6,
Ah,
I have a prior respondent.
what is the matter?
Here the petitioner, this commentary 6 has
Ah,
excommunicated the petitioner
yes.
from the community. That's the issue.
The question is whether the present writ petition is maintainable under Article 2 to 6.
Ah. How can you excommunicate?
Then I'll come to, before that, I have to satisfy the court whether it is maintainable under Article 2 to 6.
Forget
Because
about,
under
forget
this-
about the maintainability. How you can
That's why I'm going to
excommunicate like
file
this?
one preliminary objection. By tomorrow, I'll file.
Hmm.
So if it can be listed on 12, we'll argue on that day.
Okay.
Lordship.
On the prayer of Mr.
Age of my lord.
Ejo, land counsel for the petitioner. L as a counsel for the respondent. Respondent number 3 to
3 to 6.
3 to 6. And the prayer not being objected to, and the prayer not being objected by Mr. Land counsel for the petitioner. Let this matter be listed on 12th.
My lord.
It will be very interesting. Very interesting. Huh?
According to me, it's not maintainable.
No, we'll not go for the
Not
technically, but we'll be more interested in the merit. How can you excommunicate like this?
I'll satisfy the court on that day.
Okay.
But
Yes.
May I please, Lordship? Lordship, I would to mention item 15.
15.
Lordship.
Yes.
On behalf of AIME.
Huh?
On behalf of AIME.
AI?
AIME.
Ha.
Lordship, can you list this better after 2 weeks?
Why?
Lordship, she is in this post.
You are for a petitioner.
I'm for the state, Lordship.
Okay. Any affidavit has been filed?
Lordship, she's in this post.
Okay, on the prayer of so and so, huh? Let this matter be listed after 2 weeks.
Lordship.
Hmm.
Lordship, I also like to take to mention item 20 on behalf of S. Cham.
No adjournment. Hearing no adjournment.
Lordship, she have some personal difficulties, Lordship.
Call her. For state.
Lordship,
Ha. Call her. Give the second file.
Lordship,
We'll see if there any difficulty, we'll see.
Lordship,
You get this, have the second file?
Lordship.
Hmm.
Lordship, item 14.
Hmm.
I made a receive instruction.
Okay. That's this.
Letter after 4 weeks, Lordship.
Not 4 weeks, 3 weeks. Hmm. On the prayer of so and so, land council for the state council.
For the state, Lordship.
So let this matter be listed after 3 weeks. So as to enable her to file affidavit in opposition.
Lordship already filed, Lordship. On
Then,
the last occasion,
then
I'm
you-
directed to sought some instruction, Lordship, regarding the TLVC.
Your Lordship, there's an order,
Hmm.
if I may. There's an order on 5th/2nd, 2026,
Yeah,
where
say
it has
what?
been directed to the state government to give an update regarding the DLC verification.
Then you said in the prayer of Ms. So-and-so, land council, state council, for that 2 weeks time is granted to 10 instruction as directed by this code. It's as directed on 05/02/2026. Yes.
Thank you, Lordship.
If I please the court. Lordship, I'll take to mention item number 19.
19.
Definitely.
Yes.
Here on for the respondent number 4, 5, and 6.
Ha.
Lordship, if this court can kindly grant me 4 weeks to file my affidavit.
Ha. On the prayer of Mr.
Akshay Chasi,
Learned Counsel for the respondent number
4, 5,
Respondent
and 6.
4, 5, and 6. Let this matter be listed after 3 weeks. so as to enable him to file affidavit in opposition,
Just lordship.
right? Mr. M.S. So-and-so and are present, huh? Yes.
Much obliged. Okay, please, lordship.
Yes,
Lordship, I beg to mention item number 24, lordship.
24,
Lordship.
no adjournment. Why?
Lordship, if this item may kindly come out of 2 weeks, as my
No.
senior is out of station,
Why?
even the government authority
Huh?
turns out to be in disputes.
Who is appearing? What is the matter about?
Yeah.
In that would be lordship.
We'll see. No adjournment.
Lordship.
Give the second file. You take the second file.
Lordship, I have my.
You have. Then prepare and we'll dispose of the matter.
Yes.
All right.
It should be the.
Yes, yes.
Second one.
Yes.
For motion, item number 1.
Why this is listed WPC?
Lordship,
There is a notification that if its matter is 227, it should be CRP,
the Lordship,
civil revision petition.
it is revision, but it is under, it is 287, so it's a, it's.
There is no appeal, there is no appeal provision against the decision of
No,
the.
your lordship, this is a matter where the matter was taken up without any jurisdiction, without there being any law on the matter.
Tell us what is the matter?
Yes, it's a very interesting matter, your lordship.
Not interesting. Very simple.
Your lordship, it's a simple case, but then the deputy commissioner could not have referred an application submitted before him for giving a direction to the village council to issue its judgment.
Ah.
The deputy commissioner, instead of passing appropriate orders, referred the matter to the Tobashis. And the Tobashis took it as a normal case and decided on the matter. So that is the foundation which is illegal, your lordship. It cannot be done in that manner.
You wanted the judgment, copy of the judgment.
Copy of the judgment from the village council. Because the village council took up the matter, village council refused to give the
You want
judgment.
to, don't you want to resolve the matter?
No, but the matter which has been decided by the village council cannot be taken up by the Tobashis because they have concurrent jurisdiction.
Oh, is it?
Concurrent, yes, your lordship. Under the.
Against the decision of the village, Davasis,
Yes.
is there any appeal lies?
The bill lies to the deputy
You
commissioner.
file an appeal.
Your lordship, without the judgment, because there is no judgment at all. How can we file an appeal?
If there is no judgment, nothing.
But then, your lordship, the.
You said that- sorry.
There's no judgment.
You said that the Davasis has decided the matter.
The Tobashis took up the matter without me filing any case. Because under the rules, I have to file a case before the deputy commissioner. A normal suit before the deputy commissioner. If the deputy commissioner deems it necessary, then it may be endorsed to the Tobashis. Otherwise, the deputy commissioner has to take up action. But here in this case, what we filed was not a suit before the deputy commissioner. Because the village is, the deputy commissioner has supervisory jurisdiction over the village council. Here in this case, the village decided the matter orally, and then when we submitted before the village council, that the village council told me to sign on the judgment as accepting the judgment. I said, no, I'm not accepting it. So if the court will permit, we will go for the traditional swearing by the traditional customary method. That is, 5 years ingested by the two parties. Now, when I objected, the village council decided not to issue the action. And then they adjourned indefinitely. What happened was, after that, they tacitly allowed the private respondent to take over the land. So I submitted complaints They say you go anywhere you want, we don't know what is going on.
What is the
That is when-
what is the impugn order? I mean, any order?
Yes, the impugned judgment is at page, there are two impugned judgments, Your Lordship.
Hmm.
Page 27 is the one which was passed by the Tobacco Court.
Hmm. Then,
This is the, here, the, after the TC referred it to them, the Tobacco. And interestingly, the private respondent, that is respondent number 4, is the Tobacco himself. Now, after this, we filed the petition, filed an appeal before the TC. And the next judgment is at page 44. We are,
44.
yes, page 44. Annexure F.
Ah.
So this, and if Your Lordship will see here, here also this hearing was taken up by 2 SDO civils, and the judgment was passed by the Deputy Commissioner himself. Your Lordship will see at the front. Presiding officers, Sri Atrong SDO Civil Shamadro first hearing on 28 July 2025. Sri Bodhi Kafo SDO Civil Shamadro second hearing on 28 August 2025. Deputy Commissioner was never there. Then this judgment was passed by the Deputy Commissioner.
Against this judgment or judgment and order, is there any provision for appeal?
Yes, the provision for appeal is under Rule 31 of the.
Then you file an
Your
appeal.
Lordship, the foundation itself is bad. Your Lordship. There are many cases where if the foundation is effective, then the entire structure.
That can be taken care of by the appellate court.
No, Your Lordship,
Appellate authority.
even this appeal was not necessary, Your Lordship. Even this appeal was not necessary because the initial judgment passed by the Toba case is not.
Known as.
Yes. it is
According
not
to-
as-
Okay.
None is, Your Lordship.
Mr. Onganar, learned counsel for the petitioner. By instituting this petition, the petitioner has put to challenge the order dated 10/07/2024 and 17/11/2025. Whereby the passed by the Tobasis.
One is Tubashis, the
Passed by the
July is Tubashis.
Tobasis. What do you call it?
DB's.
DB's customary court.
Yes, they call it customary court.
Stamator and deputy commissioner.
Yes, Deputy Commissioner.
Deputy commissioner. Deputy commissioner Samatar, whereby the land disputes in respect of what is this? Sangpur village.
Yes, Sangpur village
Sangpur village
between
has
the
been decided in favor of the respondent number
4.
4. Mr. Issue notice, return 4 weeks. Who is appearing for the
I'm for the state lordship,
Ah.
for 1 and 2.
as Miss MS so and so learned council, state council enters appearance and accept notice on behalf of respondent 1 and 2. No formal notice need be served. However, extra copies be so and so served to the learned state council within 2 days. During the course of the day, you just
Your Lordship.
learned counsel for the petitioners to take steps for service of notice after respondent number 3, 4, and 5 by speed post as well.
Your Lordship, also, if Your Lordship may allow that for Dusty service.
Dusty?
Dusty
Yes.
also. And in the meantime, Your Lordship, the impugned orders may be
Why?
suspended state.
Let us.
Because Your Lordship, if this is allowed to
Ah.
continue, the private respondents are now.
Then you say,
Yes.
hard on interim prayer, considering the submissions of learned counsel for the
Lordship,
parties,
interview continued.
Ah. Parties to maintain status quo.
Your-
Maintain status quo.
Yes.
And
For admission, item number 17.
My lord, item number 17, my lord, I'm appearing for the respondent,
Yes.
Power Grid Corporation. My
Hmm.
lord, a very basic gist of this case is, my lord, that sometime in the year 2015 and prior to it, we completed the construction of a transmission system, my lord.
Hmm.
So this particular tower location
Are you a
partially,
petitioner?
it's,
Are you a
no, my
petitioner?
lord. I'm the respondent, my lord.
So we'll hear the petitioner first. Yes.
My lord.
Your lordship, we are presenting on behalf of my senior, Excommunication. Your honor, I was instructed since on the last order, the honorable court was pleased to file the additional affidavit
Yeah.
by the respondent. So we'll go with that, your honor.
Who is for private respondent? Yes.
Respondent number 6.
Ah. Who is appearing? No, nobody is appearing today. Respondent number 6. Who is appearing for the respondent number 6?
My lord, I am for Power Grid,
Yeah.
6 and
Yes.
7. 6.
Yes,
and 7,
you are
my lord.
supposed to file an
Additional affidavit.
yes.
My lord, we are, that's what, my lord, I'm submitting. We are just awaiting certain more documents to receive and we will file it. My lord, we'll require another 2 weeks.
Have you shifted that thing? Tower?
No, my lord. My lord, we want to shift it because of their quarrying activity. The land has become unstable. But the adjacent land from where we want to shift, my lord, the landlord over there is giving us a little bit of a problem. So we are in talks with the district administration. That is the only impediment now, my lord. Even we have to shift because we fear that the land is unstable because of their quarrying activities at the foot of the hill.
But what is your right?
Your lordship, I am limited with.
Okay. You want some time in that case?
My lord, two more weeks may be given to me. We'll file an affidavit, additional affidavit.
Mr.
N. Khera, my lord.
Learned counsel for the respondent number extended counsel. Learned counsel for respondent 6. Further, 2 weeks time is granted to file additional affidavit. So, as regard to bring on record the
Latest development, my lord.
latest development, huh?
My lord, I'm for 6 and 7, my lord. 7 also, my lord. 7 also, 6 and 7.
Yes.
2 weeks. Highly obliged, my lord.
For hearing, item number 20.
Yes. Yes.
Petitioners to present.
So,
Lordship, I am appearing on behalf of my full lordship.
then
Lordship, kindly come to paragraph 3, page 1 of the affidavit, Lordship. Page 1, paragraph 3.
Page 1,
Paragraph 3, Lordship.
page
Page 1, Lordship.
of what?
Paragraph 3.
Page 1 of what? Affidavit?
3, Lordship, in my affidavit, Lordship.
Yes.
That the petitioner begged to state that the petitioner has been praying for regularization of his service, but the respondent authorities failed to consider the petitioner case, stating that there was no vacancy in the office. The petitioner, by a representation, stated 4/12/2020, prayed for regularization of his service against the resultant vacancy that arose due to the death of 130
Affidavit in opposition of what?
for the state, Lordship.
What it is? Yes. Respond number 3.
For all the respondents.
Okay. 1, 2, and 3.
Lordship.
Implies the order of response. Affidavit in opposition. Yes.
Lordship, paragraph 3. If I may be able to read it.
Yes.
That the petitioner begged to state that the petitioner has been
Affidavit in opposition on behalf of 1, 2, and 3.
Lordship.
Okay. Yes. Para 3.
Lordship.
Yes.
That the petitioner begs to state that the petitioner has been praying.
No, I'm not getting it. This is something different. The proposal to conduct DLRB as stated by petition of the representative could not be in consideration which the office of the
Lordship.
I'm not getting it. Yes. Where it is? Running page, any running page? Running page? There's an affidavit, yes.
Mhm.
Yes, Lordship.
Ah.
And for the petitioner, Lordship. Lordship, here I'm praying for the regularization of the service. Lordship, here I was initially appointed on 19 to 2024, Lordship. Under the office of the Office of Deputy Commissioner, Village Card Longland, Lordship. Lordship, thereafter, after the death of one trade, Mr. O. Mr. Swen's of Lordship, vacancy areas, Lordship. Thereafter, due to vacancy, I sent my proposal to the government for regularization of my service. Thereafter, the state turned down my proposal, stating that there is no vacancy, Lordship. Thereafter, in their affidavit, additional affidavit, they stated that there is a vacancy, Lordship. The district level recruitment board is yet to conduct the verification, Lordship.
So what is the process of appointment? Is there any provision for regularization of the service?
Yes, Lordship. The first when there is a vacancy, Lordship, district level recruitment board, they have to verify the case.
Is there any rule how it is to be done?
Lordship, I'm claiming regularization in term of when dated 22/9/2024, Lordship.
Memorandum.
Yes, Lordship.
Where it is?
Lordship, Page
41.
Lordship.
Huh?
Page 41, Lordship. Page 41, Lordship. Roman 1, 1, 2, 3, and 4, Lordship.
Huh?
Page 41, Roman 1, 2, and 3, Lordship. 2, 3, and 4.
2, 3, and 4.
Yes, Lordship. And Lordship, if your Lordship, you kindly turn to page 40, Lordship. Page 40, Lordship. Page 40, number 5, Lordship, serial number 5, Lordship.
Page?
Page 40, serial number 5, Lordship.
Page 40?
Yes, Lordship. It's serial number 5, Lordship. Clearly state that there is a reluctant vacancies created due to the date of 1/3 so LDA on 1st December 2020, Lordship.
You are?
Lordship, I was appointed as on contingent basis, Lordship. Since at that point of time, Lordship, on that office, there was only one LDA. And the workload
See,
was,
this LDA class 3 BG office Longland,
yes,
resultant vacancy created due to death of O so and so.
yes, Lordship. After the upgradation of Longland, Lordship, to a full-fledged district, Lordship, proposal was sent for creation of LDA post, was submitted to the government by the district commissioner, Lordship.
Yes.
Thereafter, my proposal was rejected, Lordship, stating that there was no vacancy, Lordship.
Where is there is a vacancy?
Yes, Lordship.
Yes, madam.
Lordship, I mean, from that, the case of the petitioner, case to be considered, has and when DLVC will sit, Lordship.
Okay. Is it so?
Lordship.
Where it is? Where you have stated?
Lordship, it's there in the affidavit, additional affidavit, Lordship. Yes. Additional affidavit, Lordship, it's at page number 3, Lordship.
I don't know. Affidavit on additional affidavit on behalf of?
State respondent 1, 2, and 3, Lordship. Paragraph 4, Lordship.
Leave for in-service regular service under deputy commissioner. Consider. Okay. Heard, Mr.
Insakajish, Lordship. Insakajish, Lordship.
You're right, huh? It's given here.
Yes, Lordship, it's there in the class, Lordship.
Nishuka.
Yes, Lordship.
Nishuka Chichi.
Yes, Lordship.
Okay. Learned counsel for the petition and also had MS.
Pichana.
Learned state counsel. All the respondents
Lordship.
for state response. By next para, filing this writ petition. The petitioner is for a direction to regularize the service, to regularize his service in terms of the office memorandum dated 22/9/2004. by conducting. No, it's okay. Please stop. The next paragraph. Briefly put, the petitioner was initially appointed as contingency paid LDA on temporary basis under the establishment of Deputy Commissioner Longlang, in a fixed pay of rupees 750 per month with effect from 19/4/2004. List of not police and is serving on such capacity for the last 18 years. You just say Deputy Commissioner and ex officio commandant. Was a village guard.
Yes, Lordship.
Ex officio commandant village guard after Deputy Commissioner. When I said under the establishment of Deputy Commissioner and ex officio commandant BG village guard. Next para, the Deputy Commissioner and ex officio commandant village guard Longlang, has forwarded the case of the petitioner for regulation of his service on 31st 31/10/2012. However, the same was not same was turned down. List of. It is the case of the petitioner that there's a vacancy. There's a vacancy.
Yes, Lordship.
Vacancy of what is called LDA. Vacancy of LDA
For regularization.
on account of due to death of one what or Nangba.
Yes, Lordship.
Or Nangba form for which the petitioner could be for which the service of the petitioner could be regularized in terms of the office memorandum so and so. Office memorandum is page
41, Lordship.
Office memorandum. Office memorandum dated 22/09/2004. Mr. So and so learned concept for the petitioner submits that since there is a provision since there's a policy and scheme for regulation service of the workers employees, the respondent authorities are did you want to consider the case of the petitioner for regulation of his service? List of non-consideration of the case of the petitioner is against the is non-consideration of the case of the petitioner for regulation of service despite the vacancy and despite the vacancy and the office memorandum which provides for regulation of the service is amounts to what do you call it? Amounts to deprivation of the right of the petitioner. Therefore, he prays for a direction to the respondent authorities to consider the case of the petitioner for regulation of his service on the in a vacancy. On a vacancy due to the death of Sri and let P. Noklo Pom.
Yes, Lordship.
List of MS so and so Land Council for the Land State Council clearly submits that the case of the petitioner he submits that for the Longling district, a meeting of district level. What is our
District level recruitment board.
for in-service regulation of the employees under the deputy commissioner was held on 02/03/2022 and the approval for and the approval was sought for on 13/03/20 and 05/2022. The district level recruitment board specifically for district administration exclusive of village guard organization, and as such the petitioner the case of the petitioner with regard to resultant vacancy due to demise of late O Nangba form was not taken up. However, the case of the petitioner shall be considered as and when district level recruitment board sits for the village guard organization. Please stop. The next para, I've considered the submissions of the council for the parties, and also peruse the materials available in the court. The state of Nagaland as the policy and scheme for regulation of service of work choice employees. This stuff. Not police stuff, to that effect, an office memorandum dated 22/09/2004 has been issued by the Additional Chief Secretary to the Government of Nagaland, whereby it internally provides that the regulation of work choice employees will be done against available regular vacancies and the work choice employees will have the right to consider first for regulation against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regulation will be considered on the basis of seniority cum merit, which means the senior-most work charge employee in the relevant category will be regularized subject to his oblique or fitness for the vacant post. There is no dispute that the petitioner was appointed as LDA
Yes, Lordship.
on contingency basis and is serving on such post as on till date. The state respondents has fairly the state respondents has not denied the right of the petitioner for consideration for regulation of his service in terms of the office memorandum that is 22/09/2004 and made a categorical statement. Has taken a categorical statement that as in when the district, district level recruitment board sits, the case of the petitioner will be considered in accordance with the policy oblique scheme of the state for regulation of the service of the for regulation of the work choice employees. List of next paragraph. Having considered that the petitioner has been appointed on contingency basis as LDA in the year 2004,
Yes, Lordship.
who has been serving till that
19 to 2004.
who has been serving till that, and considering that the state had their policy, the policy and the scheme to regulate the policy for regulation of the work choice employees, which is stated to be invoked, I deem it appropriate to dispose of this writ petition with a direction to the respondent authorities to consider the case of the petitioner for regulation of his service strictly in accordance with the policy oblique scheme for regulation of service of work choice employee by office memorandum dated 22/09/2004 within a period of within the period of 4 months from today.
Lordship, 5 months, since we cannot give a time insurance when the other person, Lordship.
5 months.
Lordship.
No, not 5. 3 months. You consider it if she is entitled, he's entitled.
Yes, Lordship.
4 months, huh?
Lordship.
From today, it is ordered accordingly. Huh? It is according to order. It is hereby ordered accordingly. Huh? It's the same disposal.
Item number 21.
Yes.
Mr. Lordship, I'm appearing on behalf of counsel for the petitioner Zasitone. Lordship, the senior counsel is indisposed. Lordship, if the matter may come up after 2 weeks, I have taken counsel from the opposite party. Yes, Lordship.
What is the matter all about? What is the matter all about?
Lordship, I was on behalf of my colleague, so Lordship. So. I have no instruction, Lordship.
No instruction.
No.
You don't have the brief.
Lordship.
Huh?
Yes, on behalf of my colleagues, Lordship.
What to do? What to do? What is the matter about?
Retirement benefits.
Huh?
Retirement benefits.
You don't want.
The matter is about retirement benefits.
Then? Why are you not paying? Why you are not paying?
Lordship, I'm on behalf of my colleagues, so I don't know what Lordship.
Have you filed the affidavit? Have you filed the affidavit?
Lordship.
What is your stand? Why you are not paying?
Lordship, my humble apologies. I'm on behalf of my colleagues, so I don't have an instruction, Lordship.
See, this is a listed for a hearing. Parties represented by MS. Your name, please.
Yakribinyo.
On behalf of?
Sir Zasitone.
You get it, ne? And MS so-and-so State Council submits that the arguing councils are indisposed today. Therefore, phrase for listing of the matter after 2 weeks. Considering that the next para, considering that the parties are the arguing counsel is indisposed, let this matter be listed after 2 weeks.
To pledge ownership.
For hearing, item numbers 22 and 23.
This will be taken up 2 o'clock. 2 o'clock, but then I think this will be adjourned. I think they'll say something. 24.
For hearing, item number 24.
Yes.
Yes, Your Lordship.
Hmm.
Lordship, I am challenging the appointment of private respondent on the ground that it was done without following the process of law. That is without advertisement or without any interview was being conducted.
Okay.
The brief of the fact in a nutshell is that one vacant post of medical attendant arose at Hangfa subcenter that is under the establishment of chief medical officer worker. And I being eligible for the post, I have submitted my candidature in the early part of 2019. And while awaiting for advertisement or interview to be closed, the department has appointed private respondent without following the due process of law. That is without any interview and that is without any advertisement. And in support of my case, Lordship, I would like to rely on State of Odisha versus Mahanta Mohanty. Relevant para is para 35 and 36. May I read out, Lordship?
35.
35 and 36, Lordship. May I read out? At one time, this court held of the view that calling the names from employee exchange would curb to certain extent the meaning of nepotism and corruption in public employment. But later on, it came to the conclusion that some appropriate method consistent with the requirement of Article 16 should be followed. In other words, there must be notice published in the appropriate manner, calling for applications and all those who applied in respect thereto should be considered fairly, even if the names of the candidate are requested for employment exchange. In addition, thereto is mandatory on the part of the employer to invite applicants from all eligible candidates from the open market by advertising the vacancies in newspaper having wide circulation or by announcing in the radio and television, as merely calling the names from employment exchange does not meet the requirement of the said article of the Constitution. Para 36, therefore, it is settled legal position that no person can be appointed even on a temporary or ad hoc basis without inviting applications from all eligible candidates. If any appointment is made by merely inviting names from the employee exchange or putting a note on the notice board, etc., that will not meet the requirement of Article 14 and 16 of the Constitution. Such a course violates the mandate of Article 14 and 16 of the Constitution of India. It is deprived the candidate who are eligible for the post from being considered. A person employed in violation of the provision is not entitled to any relief, including salary, for a valid and legal appointment. Mandatory compliance with the said constitutional requirement is to be fulfilled. The equality clause enshrined in Article 16 requires that every such appointment be made by an open advertisement as to enable all eligible persons to compete on merit. Lordship, here I am being aggrieved because I was not.
You are also working.
Lordship.
You are also working.
No, Lordship, I'm not working.
You want the post should be
advertised.
It should be through a proper selection process.
Lordship.
Okay.
As I have said, I was.
Who has been appointed?
Lordship.
Who has been appointed? Respond number 6. Huh?
Yes, Lord.
How you are appointed? Uda is the process?
Exactly, you. Before coming to my affidavit, kindly brush the facts. Your Lordship, so far the land is concerned. I'm also one of the landowners. And Your Lordship, the land has been donated not by an individual, but by a group of villagers, a community, which will be referring as a Hangmo village, Your Lordship. And And it also appears that my grandfather has been one of the main founders who have donated the land to the government. And it has been more than 30 plus decades since I have not claimed or assailed anything from the government. However, despite your lordship, contrary to my case, your lordship, the petitioner, they have already claimed into 2 occasions, your lordship, on the basis of land only. If I may take my lordship to batch number 3, your lord.
They have been appointed.
Yes, your lordship.
What is the policy of appointment?
You-
I mean,
your-
the landowners, landowner or whatever.
Your lordship, to my understanding, as far as the land has been donated to the government for free of cost, your lordship, there is a one-time relief for the appointment of grade 4 balls, your
Where
lordship.
it is? Where is that policy? Where is that scheme? Is there any scheme?
Your lordship, as of now, I haven't reflected, your lordship.
Huh?
Lordship, if I may include lordship. Lordship, the question of land ownership does not arise. It is a community donated land. And if at all, if they're claiming without.
Let us see. Where is the appointment order? Where is the appointment order?
Appointment order is on Annexure 5, your lord.
Page 22 until the day of the petition.
Huh?
Lordship.
Page
22. Annexure F. Type copy is in 22, lordship.
consider of approval of the government of Nagaland, Department of Health and Family Welfare, Kohima mentioned so. The following is hereby appointed as medical attendant at Hankyu. Under the health and family. Benri Abum, you are Benri Abum.
Yes, your lord.
Go. Let there be advertisement.
Thank you, lordship. If I may be allowed to place a few suggestions, your lord. The only approval at the government that has been considered in my case state, your lordship, is taking more than 30 years.
Where it
because
is?
I
Huh?
don't accept any from the state government, your lord.
Huh?
Since it has been more than 30 years, your lord.
What is the scheme? That once you are a donor of the land, in lieu of that, you will be given the appointment. What is there any policy? Is there any policy, scheme, anything like that? Also, it's not by you, it's by the community.
Exactly, your lord.
If
So
the
in respect of
community,
these, your lordship, I
Huh?
also in respect of these, your lordship,
it's by the community.
I've obtained
What's the
a-
policy to appoint? In case you donated the land by the community or the individual, it's a fair submission. I mean, fair claim. He may not be appointed, or he or she may not be appointed. Go.
Yes, your lordship. Since I cannot embrace this honorable court for my appointment, however, your lordship, the prayer that is being made by the petitioner, your lordship, they've already assailed it, your lord.
Huh?
On the basis of land ownership. On the basis of land ownership, they have already assailed.
They have already availed.
No. On the basis of land ownership, your
Huh.
lordship, they have already claimed the entitlement for the grade 4 balls. So
They have claimed.
yes, your lord.
They've been appointed.
Yes, your lord. If I may take my lordship to my affidavit.
No, it's
Yes, your
okay.
lordship.
The problem is, unless until you show any policy or decision, I mean, policy decision of the state to appoint in a government job, in those who to those who have donated the land, where it is. It's against the, constitutional scheme of public employment. All of you pass, let there be interview, advertisement. All right.
Let me do my lordship.
Yes, take down. Yes, madam, how you are reporting like this? Huh?
Yes, lordship.
How you are making an appointment like this?
regarding the private responsibility.
Yes. What is this? What is this? How you are appointing like this? Tell us, what is your stand?
Lordship, may kindly come to page 3, paragraph 5.
3 of what?
That, Lordship, if I may be allowed to read, Lordship.
Ha.
That with regard to the statement made in paragraph 4 and 5 of the resolution, the development respondent states that the state government could make appointment against the state vacant post as COVID-19 pandemic hit the whole country, wherein the state of Nagaland was also severely affected and the matter was delayed. Meanwhile, several applications were received from the Chief Medical Officer Woka, which the Principal Director, DHF Sepulveda, later dated such and such, and exercise of the writ petition. Forwarded the applications to the state government for its necessary approval and decision. Paragraph 6. That with regard to the statement made in paragraph 6, 7, and 8 of the petition, the department begs to state that the state government, upon consideration, found the private respondent number 6 candidate to be qualified and eligible to be appointed to the post of medical attendant. Therefore, the state government, right letter dated such and such, an excerpt of the writ petition, conveyed its approval in favor of private respondent 6. Accordingly, upon the approval of the state government, the Principal Director DHF Sepulveda ordered such and such an excerpt F of the writ petition, appointed the private respondent number 6 to the post of medical attendant against the vacancy posed due to the retirement of Sri Chungara at Hanggu Sub Center under the establishment of Chief Medical Officer Woka.
Lordship, the government claim is that it is said the private respondent was appointed on merit basis, that is qualified and eligible. Even assuming that he is eligible, but the same is like contrary to violations of the apex court judgment, that is without an advertisement. And the same was not validated. They have not proved anything that he was an eligible candidate. Even otherwise, it is total gross of violation of the apex court judgment.
Okay. 5 minutes, huh? 5 minutes. Not 5 minutes. Yes. What to do? No option. Huh?
Your Lordship, my only and humble submission before Lordship is that
Huh?
it's been more than 30 plus years since I have not received any appointment or any monetary on the basis of land.
So, this is by the community, not by you.
Exactly, Your Lordship. So in respect of this,
Huh?
so Your Lordship,
Where is the policy that if you donate the land, you will be provided with the government job? Where is there? Where it is? Where is the policy on the scheme? Go. No other way. No option. Huh? Yes. We'll set aside your appointment. We'll direct you also participate. Let there be advertisement. All right. Heard Mr.
J. Newman.
Learned counsel for the petitioner. And also heard MS. Learned counsel, state counsel for the for respondent number. Huh?
1 to 5.
1 to 5. And Mr.
Jin Yang Hong for respondent 6.
For respondent number 6. Next para. Challenge made in this writ petition is to the order dated 14/10/2024, page 23, huh? Passed by the Principal Director, Director of Health and Family Welfare, Government of Nagaland, whereby Sri Benri Obung, respondent number 6 hearing, has been appointed as medical attendant at Hankyu. What is this? SC is what?
HANKVU.
Hankyu SC is what?
Subcenter.
Hankyu Subcenter under the establishment of Chief Medical Officer, Waka, in the Department of Health and Family Welfare. List of briefly put, the case of the petitioner. No. Briefly put, the case is of a very narrow and limited compass. List of the petitioner is assailing the administrative approval dated 30/09/2024 issued by the Deputy Secretary to the Government of Nagaland, Department of Health and Family Welfare, for appointment of respondent number 6 as medical attendant, and the consequent imperial order dated 14/10/2024 issued by the Principal Director, Director of Health and Family Welfare, Government of Nagaland, appointing the respondent number 6 as medical assistant attendant in Hankyu, what is this?
Hangfu village.
Hankyu sub-center and the establishment of chief medical officer, comma, Waka. List of next para. It is the contention of land council for the, and it is the contention of the petitioner that the appointment of respondent number 6 has been made without following the due process of law, as the said post was neither advertised nor interviews conducted. List of Mr. So-and-so, land council for the petitioner, submits that one vacant post of medical attendant had arisen at Hanku subcenter and the establishment of medical officer as chief medical officer due to retirement of Sri Sungri Rao Lota on 31/03/2019. The petitioner, being eligible for appointment against the said vacant post, submitted her candidature to praying for consideration of her case as an indigenous candidature of the district. However, the petitioner, the respondent authorities, without considering her case, has considered has appointed the respondent number 6 without due process of law. List of, therefore, he submits that the respondent authorities may be directed to fill up the post by following the due process of selection. List of. Next page. MS so-and-so, what is your stand? What is your stand?
Page 3, paragraph 5, Roshi. Paragraph 5, 6.
Affidavit of what?
For the state respondent, Roshi. For respondent 1 to 5.
1 to 5, yes. MS so-and-so, land council for the land state council submits that the vacancy which has arisen due to retirement of one Sri Sangrai Lota, applications were received from various applicants, including the petitioner, for seeking appointment, which was duly forwarded by the chief medical officer, Walker. And accordingly, the principal director, Directorate of Family and Health and Family Welfare, had forwarded the applications to the state government for necessary approval of decision. List of. The state government, the respondents could make the appointment in favor of the respondent number 6 against the said vacant post as COVID-19 pandemic due to COVID-19 pandemic please stop. No, as I said, and no selection process could be taken up due to COVID-19 pandemic. COVID-19 pandemic. She submits that upon consideration by the government, by the state response, the respondent number 6 has been found to be qualified and eligible to be appointed to the post of medical attendant. Therefore, on being approved by the government in favor of the respondent number 6, the respondent number 6 has been appointed to the post of medical attendant against the vacancy. Appointed list of. The state response have considered all the applications, including the application of the petitioner, and having been found the respondent 6 more eligible and qualified and eligible, the petitioner, the respondent 6 has been appointed in the post of what is called it? Medical attendant. What is your submission?
My submissions, depending on to my affidavit filed by the respondent number 6, page 2, bear number 5. Bear number 5 and 8 of the language. Bear number 5 and 8.
Affidavit in respondent number 6, yes. Para 5.
Yes, sir. Page number 2.
Mr.
Kingdom Police.
Learned Counsel for the respondent number 6 submits that the land where the subcenter is established belongs to the community of Honohanku village, and the respondent 6 are also one of the landowners for establishment of the subcenter. For that, the Hanku Village Council has issued a certificate on 24/03/2011. Therefore, the appointment of the respondent 6 is in accordance with the policy of the state for appointment to those landowners who has donated the land for establishment for government establishment. he submits that, a further submits that the family members of the petitioner have already availed the employment opportunities on 2 occasions. As one Mr. Sanbemo Obung, the close relative of petitioner, has served as the medical attendant at sub-center Hanku, and after his retirement, another relative of the petitioner, namely Mr. Renben Obung, was appointed against the retirement vacancy, and he is still serving as medical attendant at the said sub-center. None of the family members of the respondents were offered any opportunity for government service, which is substantiated by the recommendations of the village council of what? Village council of what? Village council of Habangku.
Ono Hango Village Council.
Huh?
Ono Hango Village Council.
Ono Hanku by the village, Ono Hanku Village Council, huh? Therefore, there is no illegality in appointing the respondent number 6 as medical attendant, right?
Yes, Your Lord.
Consider the submissions of next para of the Land Council for the parties, and also peruse the materials available on record. Admittedly, the respondent number 6 has been appointed as medical attendant, huh?
Yes, Your Lord.
By the principal director, director of health and family welfare, government of Nagaland, without due process of law, due process of selection, huh? With a deep process of selection. The only consideration appears to be that the applications for appointment to the said post have been considered by the government, and the approval was granted thereto. List of the petitioner and the respondent number 6 have submitted their applications for appointment as medical attendants at Hangbu Sub-Center under the establishment of Chief Medical Officer Waka. List of next para. There is no dispute that no selection process was carried out for appointment of the to the post of medical attendant at Hangpu Sub-Center, Oka, as no advertisement was issued providing providing all the eligible candidates to participate for appointment to the post of medical attendant. Next paragraph. It is well settled principle of law that no person can be appointed even on a temporary or ad hoc basis without inviting applications from all eligible candidates. If any appointment is made by merely inviting names from the employment exchange or putting a note on the notice board, that will not meet the requirement of Article 14 and 16 of the Constitution of India. Such a course without violates the mandates of Article 14 and 16 of the Constitution, as it deprives the candidates who are eligible for post from being considered. Plus, a person employed in violation of this principle is not entitled to any relief, including salary. For a valid and legal appointment, mandatory compliance with the constitutional requirement is to be fulfilled. The equality clause enshrined in Article 16 requires that such appointment be made by an open advertisement as to enable all the eligible persons to compete on merit. Just take it, if you need anything, paragraph 36 of this judgment. Instead of Odisha assurance. In the present case, as noted here in above, the appointment of the respondent 6 has been made without due process of selection, which is in violation of which is in the teeth of the constitutional scheme of public employment. Please stop. The petitioner, please stop. Mere submission of the applications to a particular, by the applicants for appointment to public post and its consideration on such application by the state authority would not be permissible in as much as such action of the state would be in violation of the constitutional scheme of public employment. Thus, any appointment made without advertisement or public advertisement by following the process of selection would be constitutionally would be invalid. Please stop. Next, for the foregoing reasons, I am of the considered view that the appointment of respondent number 6 is not in terms of the constitutional scheme of public employment. Stop. Accordingly, the impugn order of appointment of the respondent number 6, there is 14/10/2024 is hereby set aside and quashed. Stuff. The authorities would be at liberty No, the responding authorities are hereby directed to fill up the post by following the due selection process. By following the due process, including the advertisement, and then including by following the due process of selection. That's all. Yes. 20.
Lordship, item number 22 and 23. Lordship, here, this I just gone through the subdivisions. This matter relates to the dispute arising out of indigenous inhabitant of state. So, and of course, by seeing the petition, one is pending since 2019.
It's not pending. It has been disposed of.
Yeah. So my lordship is here. Today itself, I'll be very difficult on my part because
See, it is a cancellation of ST certificate.
Yes. Yes.
This is a judgment of the Supreme Court, Madhuri Patil.
Lordship, I will be allowed to submit some pertaining to the state.
Yes.
Now the petitioner in WBC 296, she is taking shelter under the notification 1977. And that notification 1977, that is a cut-off year.
Yes.
1st December 1963. Prior to that, resident in the state of Nagaland, they are treated as a indigenous. But now, the notification 1977 is already superseded by the notification September 2024. And there are some matters are pending in a division bench and in a single lawsuit. So definitely, if you go ahead, then definitely there may be some, that is my observation, Your Lordship. Because of the
the matter is before the division bench.
Yeah, one is
related to this.
Yes.
See, for cancellation or whatever of the caste certificate or tribe certificate, there's a guidelines by the Supreme Court. You just cannot say that, you just cannot on a drop of a hat or a stroke of a pen cannot cancel like that.
Lordship.
Even if the Deputy Commissioner found that he or she is not entitled, I mean,
Lordship.
not entitled. You cannot do that.
Lordship.
There's a, I mean, guideline. How you go, how you have to go, I mean, how you proceed with the issue. I don't know. I've seen it.
Lordship, as you stated, but today, Lordship, I'm not in a position to apprise your Lordship. That's
why?
Because
you know, it's
I just received
records.
Yes.
So that there's no, I mean, you have not, you have followed the
next week also.
You have not followed the process.
This may be releases next week.
Do you have the as per the Supreme Court judgment?
No.
In Madhuri Party, do you have the scrutiny committee in the state?
Yes, ring committee is there, and
scrutiny committee is there.
Yeah, committee is there, but it's already state.
But then when you have the scrutiny committee,
yes,
as per the I mean, guideline of the Supreme Court, why the Deputy Commissioner should cancel? Why should take up the matter?
No,
it's not authorized.
In order to ascertain all those indigenous inhabitants of Nagaland, the government has constituted one committee, 2024. But that enumeration and to ascertain the Chilean indigenous inhabitants of Nagaland. But that enumeration, that committee is state in another WPC. Is already state. So we cannot move now. And that is one question. That in
where it is? It's pending.
Yes, WBC 72 of 2025. It is filed by 4 communities.
Saying what?
That they are entitled to get indigenous inheritance certificate as per the notification 1977. And they are challenging the notification 2024, which superseded the earlier all the earlier notification.
What do you mean by this indigenous, inhabitant, what do you call it? Indigenous inhabitants certificate?
Yes. And now that is another matter. That is WBC 72 of 2025. That they are praying to quash the latest notification 2024 and praying to restore the 1977 notification. That is a cut-off year 1963. And again, after some time, another PL came up, PL 4 of 2025. So it is filed by the Nagaland Tribe Council. Now the Nagaland Tribe Council is praying to the Honorable Court that quash the 2024 notification, but restore the 1977 notification, where there is a clear cut-off year is there. So it is pending. And subsequently, another PL has come up, which is not listed. That will be listed by the next week only, Angami Public Organization, in the same line of the Nagaland Tribe Council. So those pertaining to indigenous, we are traveling in such a rough journey now. So in the meantime, if the matter is disposed of, who knows, it may complicate the issue also. That is my observation, sharing before the Lordship. In addition to my...
Yes, what do you say?
Lordship, the present rate petition, Lordship, I'm for the petitioner in WPC number 176. Lordship, in my rate petition...
176 is disposed of?
Lordship, initially the...
Wait for WPC 296.
296, Lordship, my learned friendship.
Huh?
My learned friendship.
You are there? 296.
Lordship, the leading counsel was unable to come this morning, and this Honorable Court has directed for taking up this matter at 2 o'clock. Accordingly, we have informed the leading counsel.
So he's coming.
He is ready to come and take up the matter at 2 o'clock.
Well, 2 o'clock.
Lordship, we can take up tomorrow. If my,
my humble behavior, Lordship, is
You have some difficulty today.
yes.
if it is difficult to take tomorrow. Tomorrow.
No record at all. So
No, this 2019 matter is disposed matter.
Only disposed of my rate petition, Lordship, initially it was dismissed by the single judge. I filed an appeal. In my appeal was allowed.
Then
In my rate petition was it was directed to be taken along with this WPC 296.
What is your case there?
Lordship, in my case is I'm challenging the selection of the private respondent, who is the petitioner in WPC 296, on the ground that she is not an indigenous inhabitant of Nagaland, as per the 1977 the notification issued by the FICA.
Okay, he is not.
And Lordship,
he or she is challenging the order of the deputy commissioner.
Lordship,
Additional deputy commissioner, her certificate has been cancelled.
Lordship, it happened like this. While dismissing my writ petition, Lordship, there was another writ petition filed by the private respondent also. Both the writ petitions were taken up. My writ petition was dismissed on the ground that since I participated in the selection process, I cannot turn around and challenge the recommendation.
Yes.
Which was again the appellate court questions it said the judgment of the learned single judge. While dismissing my writ petition, at the same time the learned single judge has directed the ATC Pukubutu to conduct an inquiry regarding the indigenous inhabitants of the private respondent. Inquiry was conducted in compliance with direction passed by the learned single judge.
Is it a question of scheduled tribe or scheduled caste or something like that? Or
indigenous inhabitants. Indigenous inhabitants.
Indigenous inhabitants.
So, inquiry was conducted by the ADC Bukubutu. And on the basis of the inquiry report, the state government has taken a decision that she does not qualify to be an indigenous inhabitant of Serbian. Accordingly, her indigenous inhabitant was cancelled. Now she is challenging the order passed by the state respondent in WPC 296.
What does it mean, indigenous inhabitants? What does it indicate?
Indigenous inhabitants.
So you have to be a tribal or the indigenous, thing.
The case is the private respondent number 4. Her father was a Bengali who came and settled in Nagaland during 1970s. So she does not qualify to be an indigenous inhabitant in terms of the 1977 notification issued by the state government. That is my case.
Okay.
So the matter has to be decided only on the basis of this 1977 notification, whether she fulfilled the criteria described in that notification. So the matter can be heard tomorrow.
It's not a question of ST.
No, not this.
Not scheduled.
No,
Not scheduled. Only indigenous inhabitant.
If one's qualified for to be an indigenous inhabitant certificate, then only she can obtain the scheduled tribe certificate.
Okay. Okay. So,
Lordship, if the matter is listed on draft trustee, because see, these, if I just don't attend attentively, it may be a floodgate. So, and it's a very delicate issue.
do you think that will be, will pass in slipshod order?
On my part, I cannot say anything about the judgment. So if any.
Are you expecting that the court will say slipshod
This
order?
writ petition has no relation with cases which are pending before the appellate court.
It's not.
No, Lordship. Lordship, this writ petition was
No,
filed
this
in the
2019 is
2019 issue. The
already
notification
disposed of.
The notification which is under challenge.
See, 2019, your matter you already disposed of.
Already allowed by the appellate court.
Then you have nothing to say now.
And so 176, no, Lordship. That is already allowed by the appellate court. Now, my prayer in my writ petition, it will be only
Are you
subject
responding in 296?
Yes, Lordship, ma'am.
Okay.
So my prayer in WBC 176, that will be subject to the outcome of this 296. So in the select list, the private respondent, she's in number 1, and I'm at number 2.
Okay. Once
Her candidature goes.
Once it is established that he is not or she is not an indigenous, what do you call?
Indigenous
Inhabitant. Then
my case will come for consideration.
Okay. Is the post of what?
Sweeper.
Correct.
Are we still working?
No.
No appointment.
No.
So when?
Let it on draft trustee, coming trustee.
Okay.
Your Lordship will be leaving on Friday, so it will be tight for the process judgment. Lordship, or we can take up on 10
Tuesday.
Next Tuesday.
Has agreed to by land council for the parties. Let this matter be listed on 10th 03/2026. So inform your senior that it has been fixed on 10th.